Hi, my name is Robert Shelley with Shelley Law, and my law firm assists practices in drafting physician assistant employment contracts or independent contractor agreements. So today I'm going to go through 5 main factors that kind of go into whether a PA contract is successful or not. So the first thing to think about is whether the PA is an independent contractor or employee. Now, first, there are some states where PAs cannot be independent contractors, so look into whether your state allows that or not, but many states do. And so you need to think about how you're going to classify them. The IRS comes out with a 20-factor test, kind of breaks down what makes someone an employee versus an independent contractor. So you need to classify them properly. Once they are classified, then you can kind of determine how you want to compensate them. I guess the most common ways of compensating a PA is either through just a guaranteed base salary or have some kind of net collections based agreement where they would receive a percentage of all collections received by the practice, based on the personally performed services of the PA. I find a hybrid is probably the best way to go. It gives the PA a little bit of stability with guaranteed minimum, and then also incentivizes them to work and be more productive. So you would want to tie a significant portion of their comp to the productivity. And net collections based is the most common way of doing that in private practice. It's very rare that a private practice would utilize RVUs. That's usually saved for hospitals. Or like employed, if you're employed with a hospital network or something like that. After you determine the comp, then I think restrictive covenants, probably or at least the next most important thing. So non-competition clause, non-solicit. Nightmare scenario for any practice owner is to bring in a provider. That provider leaves, takes a bunch of patients, takes a bunch of key employees, moves to a competing office nearby. So the non-compete can stop them from working for a period of time within a specific geographic area of the office. So you need to think about what would be a reasonable and enforceable amount for both of those. And then next, the non-solicit stops the PA from actively soliciting patients. And more importantly, you can word it so that they cannot hire any employees that were normally part of the practice for the 12 months preceding the termination of the agreement. And then the last thing the fourth thing would be malpractice insurance. So what type of policy you're going to utilize, either claims made or occurrence based. Most private practices use a claims made policy and then make the provider pay for tail insurance. If you use an occurrence-based policy, it's usually about a third more expensive than a claims-made policy. So save a little bit of money by offering a claims-made policy and then having the provider pay the tail. And then the last thing would be the notice requirement. So any contract is going to have without cause termination, which simply means the contract can be terminated at any time for any reason with a certain amount of notice to the other party. 60 or 90 days is kind of the industry standard. If you're the employer, the longer the better, gives you more time to find the replacement for the provider. Obviously, if you're the PA, the shorter the better, because then it allows you a little more flexibility and movement. There needs to be a balance and fairness with any agreement. When an employer tells me to kind of put the screws to the provider at any possible, place in the contract, I don't think that's the best idea. Usually those type of offices have a high turnover, and you're always searching for new providers, which is just draining. And then you train somebody and they leave, and you train somebody and they leave. It's no good. So finding a good balance between a contract that protects the interests of the employer, and also provides the opportunity for the provider to succeed, I think is the best way to go. So if you need a physician assistant employment agreement or independent contractor agreement drafted, please contact my law firm with the contact info listed below in the description. Or if you have any questions, you can leave them on video. I'll answer any questions that you have. So anyway, hopefully this video is helpful and I appreciate you watching. Take care. Bye.